Mr. Fowler, this complaint charges that in the town of Nantucket on July 8th, 2016, did commit indecent assault and battery on person 14 or over.
Sir, if you're charged with another offense while this matter is open, you can be held for 90 days without bail. Mr. DA, request beyond the bail warning, any?
Beyond the bail warning, Your Honor, the Commonwealth is requesting that Mr. Spacey be ordered to stay away and have no contact with the named victim and his family.
All right, certainly the court will impose those conditions. Anything additional?
No, Judge.
Okay, all right. No requests in terms of movement or staying within the United States, anything?
As required by the court, Judge, and as required by the probation department, our only request specifically is the stay away.
Okay, all right. Well, those will be the conditions then. Sir, you'll meet with probation. You'll sign those conditions. You'll be required to stay away and have no contact, direct or indirect, with the alleged victim. All right. I know there was a motion filed by defense. I had occasion to look at it. Mr. DA, have you had occasion to look at it?
We've reviewed them, yes, Judge.
Okay. You want to be heard on the motion, or?
Briefly, Judge.
Sure.
Regarding the motions to preserve, we agree that anything that is currently in our custody and control, we have to preserve, we will preserve, and we will turn over in discovery.
Sure.
As it relates to the motion to preserve itself, we're suggesting at this point that the scope that is being requested by counsel is overly broad. It's asking for July 7th and July 8th of 2016, but all the way up to the present. We suggest that based on what's been filed up to the present is overly broad. The affidavits in the motion suggest that Mr. Little and his girlfriend or another individual were texting contemporaneously on the 7th into the 8th. And then it says by providing this other information, we'll likely see that something happened or that he talked about it further. But there's no basis for that information within the motion to preserve. We would suggest that it's a fishing expedition at this point, and that the motion should be narrowed at least to the 7th and 8th of July of 2016.
It's a fair point. Mr. Jackson or Ms. Bolero, I don't know who's going to respond, but feel free.
I'll be happy to respond. Alan Jackson on behalf of Mr. Spacey.
Sure.
Your Honor, I don't believe at this point that we need to talk about the scope. That's something in terms of a subpoena. In other words, what I subpoena or what I serve on those individuals might require a discussion or some litigation about the scope. All I'm asking at this point is that we preserve it. In other words, this is data that we believe is not only potentially exculpatory, but likely exculpatory for Mr. Spacey. I simply don't want to see any of that data deleted, destroyed, even inadvertently, or in other words, in any other way manipulated. I don't think it's a burden at all on the Commonwealth, nor on the two individuals named in the motion, MD and the complaining witness, to simply say, I'm ordering you not to destroy anything, so that Mr. Jackson, Ms. Bolero, the Commonwealth can litigate in front of the court at some point whether or not there is exculpatory information that leads all the way up to today. In other words, all I'm asking for is just to put a bubble around that data so it doesn't get destroyed. I'm not saying I get it yet. I just don't want it destroyed yet.
Further response?
We can only control, Judge, at this point what's in the care, custody, and control of the Commonwealth.
Right.
As far as information that would be contained within the specific service providers of these individual cell phone carriers, well, that's different. We have no control over that, Judge. So we would suggest that as far as the preservation goes, whether it be to the individuals directly or to the providers, that it be limited at this point to the 7th and the 8th until more information can be provided as to why it might likely be exculpatory versus a fishing expedition.
Right. I haven't seen any of the police reports, so I don't know what, except for your affidavit, I don't know what information that you base this request upon. I do think that the 7th and 8th certainly it would be appropriate to time span to preserve the evidence, but I understand that even if the motion is allowed, it can be modified down the road and can be tightened up. And so I'm inclined to allow the motion. I don't know that I'm going to do it all the way up until, from the 7th and 8th up. I mean, I may give you maybe 6 months worth of preservation, but I don't know that I'm going to require that everything be preserved. Go ahead.
But certainly at this point, that would be satisfactory. 6 months worth of preservation, I think, is better than nothing, and
Yeah.
I'm certainly willing to accommodate the Commonwealth and the court's
All right.
guidance
All right.
on that.
So from was it July 7th?
July 7 and 8 of 2016.
Okay.
And 6 months thereafter.
All right, in 6 months thereafter, the motion will be allowed, at least there'll be a requirement that the cell phones and I think the cloud-based
data.
and then some passwords, et cetera, that all be preserved. As I say, that's subject to further modification one way or the other, depending upon what is discovered during the course of this matter. So,
Thank you.
all right, we have a further date, gents and ladies that work.
We haven't discussed one yet.
You confer with counsel.
Go ahead.
I think we can come up with a date in just a quick
Go ahead.
second.
Sure. Sir, you can be seated. You don't need to continue to stand. Thank you.
Kärleksfullkomligt ska jag sitta, det är det var mina.
Thanks. Actually, we got it. Thanks, boss.
Give me 1 second. Let me go to the calendar. Your Honor, may I consult my cell phone real quick?
Sure.
It's got my calendar on it. I apologize.
Your Honor, Mr. Jackson is admitted pro hac vice. I'm local counsel on the case. Are you going to require my appearance from someone from my office at all proceedings?
Are you in already? I know you came in so that he could enter the Pro Hoc Vice, but is there?
Yes, I do have a notice of appearance on file, and Mr. Jackson was filing one today as well.
So your appearance is already in?
My appearance is in.
Well, we'll leave it there. Thank you.
Counsel. Normal 6-week date for the president's hearing.
Yeah.
The following Monday, on trial.
I'm out.
Yeah. Can we do it the 4th? March?
That's fine.
That's okay.
Yes.
Your Honor, if it pleases the court, counsel and I have discussed informally a date of the 4th of March, which is a Monday. I understand that's most convenient for the court.
Yeah, that's right. That's jury week is in February, so March 4th would probably work. Yeah.
And counsel and I also discussed off the record, and I would ask for the court's guidance on this. He has no objection, the Commonwealth has no objection to Mr. Spacey not making that appearance. I can make that appearance on his behalf, along with Ms. Bolero, if need be, without him having to be there on that date.
No, and that's fine. His appearance can be waived. However, he should be, the rule requires that he be available, so he should at least be on the other end of the phone if there's some reason that he needs to be contacted.
Absolutely.
But his appearance can be waived.
Okay.
Sure.
Thank you.
And
Thank
can
you.
we schedule that, Your Honor, for 11 a.m. again?
Sure. All set? Anything additional, folks?
I don't think so, Your Honor.
No? All right, thank you all for your help. I'm going to step off, and then the camera people can break down their equipment, and those connected with the case can depart. Thank you very much.
Okay, this case has been continued to March 4th, 2019 for pretrial hearing at 11 a.m. The defendant's
No, they just
appearance
did.
has been waived.
Oh, the clerk's
Sir, you
report.
should report to the probation department before you leave the building in order to sign the conditions of stay away and no contact with the victim and the victim's family. Thank you.
Thank you.
Court stands in recess. So step aside, please.
What we just heard in the courtroom was some very interesting legal argument, really aggressively brought on by the defense, because when the alleged assault occurred, and the accuser says it happened for about 3 minutes near the piano bar of this local restaurant He was a busboy, off work, excited to meet Kevin Spacey. Was with him for about an hour that night, midnight to 1 o'clock in the morning or a little after, at tables, at the bar area. A lot of drinking was going on. But what we just heard in the courtroom was that when the alleged assault was happening, there was texting going on between the accuser and his girlfriend. And the defense wants to know what those texts were. Now, the accuser said to detectives that his girlfriend didn't believe him as he was saying that he was being assaulted or touched without his consent by Kevin Spacey. She didn't believe him, so he took a Snapchat video, lasted about 1 second, and it shows basically just a picture of a hand on some clothes. We haven't seen it. That's how it was described. But the defense is saying this could help us. These texts, we want to know what they are. We want everything preserved between the accuser and his girlfriend, not only July 7th and 8th, 2016, the date of the alleged assault, but 6 months after that. So that was really one of the headlines, I think, from the hearing today, the arraignment, and now the next pretrial hearing will be beginning of March.
Så länge det är blont och silikon, säger fan Horan. Gärningspersonen ska ha sitt, eller hur? Du fattar vad jag menar.
I believe this is the beginning of the end.
I do too.
It's really the beginning of the end.
The beginning of the end.
For Canadians, the past 2 years have been like eavesdropping as the neighbor's marriage falls apart.
Maybe feeling the walls closing in on him.
All the walls closing in on him.
The walls closing in on him.
Hearing the raised voices next door.
We begin tonight with the bombshell.